Hi, I'm Natalia Angelini.
And I'm Sanaya Mistry.
Welcome to Helen Estates. You're listening and watching episode number 605. And it's Sanaya's and my first time podcasting together. I'm happy to do that with you, Sanaya.
Yes, me too. I'm so excited.
So let's just dive in. We're going to be discussing attorneys for property today. We're going to be touching upon their fiduciary obligations and scenarios where it can go awry. And if we're just looking generally off the top, the Substitute Decisions Act governs guardians and attorneys and makes it clear that they need to act for the benefit of the incapable or grantor of the power of attorney. And that really has to be sort of the golden thread, the guiding theme for any attorney.
Yes, absolutely. Attorneys have a huge responsibility, a huge fiduciary duty that they have to meet. And it is very important that they sort of do everything by the book and everything that they should in the best interests of the grantor.
Right, and those obligations are varied, but when we're looking at an attorney for property, we know they've got to keep excellent vouchers of all of the receipts and disbursements and document their time, obviously not personally benefit from the post and no self-dealing. And, we're going to be touching on a case in a little bit where these obligations were not adhered to, and sadly, we're seeing more and more of attorneyship litigation. I think we've always had quite a bit of attorneyship litigation, at least in my experience, but we are seeing more and more of it, and it's particularly worrying when we have an aging population and more elderly, vulnerable people. And so I think, as this case will show, the court is really very seriously taking its obligation and fulfilling its obligation to hold wrongdoers to account. And so why don't we get into that case? This is a case that one of our colleagues, Doreen So, recently blogged on. It's called Public Guardian and Trustee and Cherneyko, and we'll put the site up on our website, but maybe Sanaya, you can just take us through the facts.
Yes, absolutely. So this case involved a 90-year-old woman who executed a power of attorney appointing her friend, who she'd known for approximately 5 years, as her attorney for property. And within the span of a few days or a few weeks of being appointed as the attorney, she was gifted $250,000, by this woman who was incapable. And not only that, but an extra additional amount of approximately $70,000 was also gifted or transferred to this attorney over that period of time. And the court was not happy about that because she had no vouchers or receipts to substantiate those expenses or those amounts. And not only that, the court noted that she has a fiduciary duty towards the incapable. And just because she said that the incapable, this is what the incapable wanted, this is what she wanted, that's not sufficient. You have the fiduciary duty to do what is in the best interest of the incapable, and this wasn't that.
Right, and I think it's one of those clearer cases where an attorney was really doing, there were multiple offenses here, right? We've got purported gifting happening very early on that the court, concluded these were not valid gifts. We've got family members of the attorney benefiting by way of her son living in the grantor's home because the grantor shortly after went into long-term care. We've got another sizable amount, I think almost $200,000 being purportedly gifted to another person who was treated as, I think, a cousin of the grantor, but wasn't an actual cousin. And even though the PGT, this was an application brought by the Public Guardian and Trustee, but even though they didn't pursue that specific piece of it, they did pursue this attorney for property, and successfully so. And it really started out as an investigation done by the Public Guardian and Trustee, which clearly they had enough evidence or felt they had a strong enough case to pursue it through to pursuing civil action. And so, I would love to start seeing less of these kinds of cases. And, this is a more blatant one, but more frequently we're seeing cases where attorneys are just, they're under scrutiny. It's a serious post, and rightly or wrongly, they could be criticized for not maybe managing the person's money in the most effective way, or in a way that maximizes their assets to the greatest extent, or maybe they're not keeping enough vouchers, and so critics can use that to try and discount their compensation. Or sometimes we have more serious steps where people are bringing applications to have attorneys removed because they're not happy with their conduct. So it really strikes me that more education for attorneys would definitely help stem this kind of litigation. And I know the bar is always, we're looking at ways to improve resources for attorneys. There's the Public Guardian and Trustee website. There's checklists and information sheets we can give our grantor clients when they appoint attorneys, that can set out an attorney's obligations. But really, I think the ideal outcome is for an attorney to get that legal advice before they take on the job.
Right, absolutely. It's so important, for an attorney to know what they're getting themselves into. When someone appoints an attorney, they pick the best person for the job that they know or that they think is going to do an amazing job as their attorney. And it's important for the attorney to know what actually this duty entails, what they have to do to satisfy the court in the event that this ever gets to the court.
Right. Unfortunately, a lot of the time, I think we've got adult children or child acting as attorney for mom and dad. And so it's a less there's a sense of like informality to it. And there can, and when you've got the opportunity to access to a parent's cash, and this role where, you're the one taking care of mom or dad, and there may be some sense of entitlement coupled along with that, can very easily slide into a misstep, intentional or not. So, I'm hoping as we work to get more and more resources to lay people who are going to take on this post, we can really see a change in this area. I'm crossing my fingers because the court will, we've got to protect our most vulnerable, and it's in the civil context. It's a challenge because it's so expensive to pursue that kind of litigation. Thankfully, we've also got that opportunity in the criminal context, because there is a criminal code offense specifically meant for attorneys for property who are conducting themselves in a fraudulent way. But it's just an avenue that's rarely pursued. Again, I think it's because we've got this less clear evidence of, stealing, theft, right? It's someone who's got the authority to act with someone else's funds. So we see it much more in the civil context, but it is, I guess, just a good note that we've got this other avenue. I think it's just a more challenging road for in many situations.
Yes, absolutely. And, like you said, hopefully with more education and more information out there for attorneys, we will see less and less of this litigation going forward, especially, with our aging population. We expect there might be more litigation, but the hope is that there won't be, because there will be more education out there.
Right. So unless you have any other comments or thoughts, Sanaya, I think that brings us to the end of our podcast.
Yes, I think it does.
Okay, well, thank you for listening and watching. I'm Natalia Angelini.
And I'm Sanaya Mistry. Thank you.
Should you have any questions, please email us at webmaster@hollandhall.com or leave a comment on our blog. Thank you.